So now we'll discuss question number 56, which was, can a lessee assign his rights under a lease to a third person? Discuss the rights of lessor as against assignee of the whole interest in the lease, a sublease, and a mortgagee from the lessee. So, the very answer that we found regarding the question, that is under section 108 subsection J of transfer of interest by the lessee, and in relation to that we will discuss the very ruling of Supreme Court in 1980 in the leading case K.K. Krishnan versus M.K. Vijay Raghavan. So now we'll discuss the very provisions of transfer of interest by the lessee as provided under section 108 subsection J of the Transfer of Property Act, which entitles the lessee to transfer his interest in lease property, which runs as follows. The lessee may transfer absolutely or by way of mortgage or sublease the whole or any part of his interest in the property, and any transferee of such interest or part may against transfer it. The lessee shall not, by reason only of such transfer, cease to be subject to any of the liabilities attaching to the lease. Nothing in this clause shall be deemed to authorize a tenant having an untransferable right of occupancy, the farmer of an estate in respect of which default has been made in paying revenue, or the lessee of an estate under the management of a court of wards to assign his interest as such tenant, farmer, or lessee. So, Section 108 of the Transfer of Property Act, as it was pronounced by the Supreme Court in this important leading case, K.K. Krishnan versus M.K. Vijay Raghavan in 1980, that an absolute assignment of the whole interest of the lessee creates privity of estate between the lessor and the assignee, and the assignee becomes liable to the lessor for all terms running with the land, including the terms to pay rent, and the lessor has got a right to enforce these against him. So, this is what we found as regarding the very assignment of his rights by a lessee under a lease to a third person, and as regarding sublease, that there is no privity of estate between the lessor and the sublessee, and as such the lessor cannot sue the sublessor for rent, and his remedy is only against the lessee with whom he entered into the contract. And now we'll go to another, that is a mortgage from lessee. So, in that connection, A mortgage of the lessee's right is not an absolute and does not create privity of estate between the lessor and the mortgagee, and as such, the lessor cannot sue the mortgagee for rent, nor can the mortgagee be liable to the lessor for the whole of the rent, and covenants and cannot be liable for any part of it without appointment, even if tax position. So, this would be the correct and appropriate answer relating to this question. Can a lessee assign his rights under a lease to a third person? Discuss the rights of lessor as against assignee of the whole interest in the lease, a sublease, and a mortgagee from the lessee. So now we'll go to the next important question, question number 57. Explain the dictum. A lessor may not derogate from his grant, and the very answer that we found under section 108 subsection C, which provides lessor may not derogate from his grant. So a lessor and lessee, while entering into a contract of lease, are deemed in the eye of law to enter into certain covenants with one another. It has been dealt with in section 108 subsection C of the Transfer of Property Act, which runs as follows. The lessor shall be deemed to contract with the lessee that if the latter pays the rent reserved by the lease and performs the contract binding on the lessee, he may hold the property during the time limited by the lease without interruption. And the second one, the benefit of such contract shall be annexed to and go with the lessee's interest as such, and may be enforced by every person in whom that interest is for the whole or any part thereof from time to time vested. So, in that connection, we will discuss the rulings of an English leading case, and that is Alden versus Latimer Clark Murray Company, and where it was the matters transfer of interest and possession, which is a right in rem. So, the above section is not exhaustive. A lessor is not entitled to reside from the lease and derogate from own grant to so as to question his own capacity to the grant or the interest that he was transferring. So it was established that the lessor may not derogate from his grant. A lease is a transfer of an interest in land is a right in rem. The lessor transfers his interest and possession and cannot subsequently take away any of his interest and possession. Such plea by the lessor, by which there is very derogation in the grant made. A lessor is stopped from impeaching his own title or grant of the lease. So, this would be the correct and appropriate answer, and the very ruling as made In the leading case, Alden versus Latimer Clark Muirhead Company, as regarding the very question, explained the dictum, a lesser may not derogate from his grant, so this should be the correct and appropriate answer to question number 57. So, in our upcoming video, we'll discuss question number 58.